what's included in the contract? What are your rights and obligations? What are the terms of the contract? Hello, I'm Ross Dillon. I'm a consultant for Queen City Law, and this is Contract 102. If you haven't seen Contract 101, please look it up and have a look at that first. The terms of a contract are what has been agreed, often as far as lawyers are concerned, best what has been written, but those are called the express terms. It's what has expressly been agreed, what has expressly been written down, what is in the document. That's relatively straightforward. If we go back to the school ground example that was used in Contract 101, you have two children in the playground, one has 2 donuts and one has a large drink, and there's an offer and acceptance. One offers to give a donut for some drink, which is fine, and you can understand that you can have an agreement there. It can be an oral agreement. It's only when you start writing the terms down that you start wondering about things like, I wonder what some of the drink is, because you're certainly getting one of the donuts. Maybe it needs to be half of the drink, and that takes you into being more particular, which is why lawyers prefer written contracts. But oral contracts are fully enforceable. It's just that they tend to have to be proved in court when you have a dispute, which can be a problem. So, express terms. What other terms are there? There are implied terms, and implied terms are things that aren't clearly expressly stated but still form part of the contract. An obvious example would be if there are statutory terms. If there's an Act of Parliament that says if you're involved in this type of contract, then these terms are implied into the contract, often whether you like it or not. Although there are some pieces of legislation which allow you to elect to have certain terms in, or to exclude other terms which will be implied unless you exclude them. So it's important when you're looking at a particular contract to consider whether there's any statutory provisions that might apply to it, because you could find yourself with a whole lot of extra terms that you really hadn't thought about. But that's only one way to have implied terms. Another way is because the courts will imply terms into a contract if there's been a dispute over what has been included and what was agreed. Now, the easiest type of implied terms with the courts involved would be what are called customary terms, when the parties are in a particular type of industry and everybody in that industry has always used a particular form of contract that will often be implied into the dealings between those two particular parties. So that's when you have an industry standard. You'll find industry standards are often the case in things like building contracts in the building industry, although those are often what's called incorporated by reference. So there'll be an express terms that says we are contracting on the basis of, and then refer to the industry standard contract. So it's not quite an implied term because you've expressly said it, but there are also industries where everybody uses a particular type of contract and those terms will be implied. There's also the prospect that you have a course of dealings between parties which might go back over many years, where the parties originally worked out very carefully what their rights and obligations were and possibly put that in writing, and in all the years since they have just referred back to or used those particular terms. The problem with that is that over time people come and go, and you can be lost in your own history as to what the terms that are going to be implied into your contract are. But if you've got a course of dealing and it has been consistent over a number of years, terms can be implied because of that course of dealing. Another case is where there's just a hole in the contract. There's nothing expressed, but obviously that hole was intended to be filled, and the courts will imply what they call imply in fact a term into the contract. The classic case is called BP Refinery Western Port Pty Limited and the Shire of Hastings. In that particular case, the court said you have to have these things to imply a term in fact. First, the term that you're seeking to imply is reasonable. Secondly, it must be necessary to make sense of the contract. In other words, it's a fairly essential part of how the contract works. Thirdly, it must be so obvious it goes without saying, which is presumably why it wasn't said in the express terms. It must be clear. And finally, and this is quite important, it must not contradict any other express term in the contract. So you can't imply something where you've already expressly said something different. Finally, I'd like to talk about almost the opposite of express terms and implied terms when you're bringing things into the contract, and that's where things are excluded from the contract, and these are called exclusion clauses. The most common type of exclusion clause you'll run into is in your insurance policy, where you'll say, yes, my car's insured, but if you look at the terms, it's not insured in certain circumstances, and those are the exclusions. So you can have that type of clause in any type of contract. You can limit or restrict the type of obligations that you are undertaking, but you have to do this quite expressly because the courts will always look a lot harder at those types of exclusion clauses. There are two basic types of exclusion clauses, one where you limit your liability, and you'll see this in an insurance company, your car's insured but only up to an agreed value, for instance. So that's in some ways an exclusion because your car might actually be worth more than that, but if you've agreed that that's your limit, that's what you'll get. There's the other type of exclusion clauses where any liability at all is excluded. And if we take the car example, for instance, you might find that you have no cover if you habitually park your car on the street, but in your insurance policy you've said no, it goes into a garage at night. Now there will be a term of the policy which says if that is the case and the car gets stolen, then you might have no cover at all. The courts do look at that type of exclusion of all liability clause very closely, and they regard it as very strict and try to limit it that way, but nonetheless, if that's what your contract says, that's what you'll be left with. So, looking at your contract, we've assumed that you've got one because you've looked at the Contract 101 video. If you have got one, you've got your express terms, but you may also have implied terms. It's really important to make sure you've got everything covered, and that's why lawyers love written contracts. It makes it just that much clearer for everybody. Thank you for listening. If you need any further help or assistance, you'll know where to find us.